Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast. This edition we look at protecting children that have substance abuse problems or grandchildren that have substance abuse problems by not giving them money outright. So we're going to go over reasons to set up a trust within a will or a standalone trust to protect children and grandchildren with addiction issues. Given the current epidemic of addiction in our society, it's natural that many families have a child who has problems with drugs or alcohol. And typically we use the word, people don't like to say addicted, but, problems with oftentimes is the same as addicted. Estate planning for addicts can be emotionally and mentally difficult because the parent likely did not want to disown the child. However, as responsible parents, a parent likely wants to assure that any inheritance the child receives is not made available to them until they are clean and sober. Taking steps to create an estate plan that considers and accounts for the child's addiction can prevent them from receiving a lump sum of funds while they are under the influence. By preventing the child from receiving too large of inheritance, the possibility of the hard-earned family assets being wasted sometimes can be prevented. So, for example, people that have kids with special needs, they always want to plan ahead, so the kids with special needs don't receive lump sums of money and lose governmental benefits. So the same thing, you want to protect children with substance abuse issues from harming themselves because of lack of control regarding their substance and access to a large amount of money. Fortunately, there are several steps a parent can take which help a parent to leave the assets to the children without giving them assets that they could use to harm themselves. While a parent should always discuss the situation with their attorney, the following include ways that a parent can make estate planning work for a parent and the child. So, understanding disinheritance. Let's see. Disinheritance is often the first option for those considering estate planning for an addict. Depending on the situation, it may become the right decision, but the parent doesn't want to consider it. Even if a parent is estranged from a child, the parents still likely care for them deeply and want the best for them. Disinheritance is the process of cutting a person out of the will so when a parent dies, that child receives nothing. While it may be tempting to some, especially if a parent believes the child will likely never get better, this decision cannot be changed without rewriting the will, even if the child goes into rehab and becomes clean and sober. If a parent chooses to disinherit the child, a parent must leave specific instructions in the will that they receive nothing. Should a parent choose to do this, it is crucial that a parent do so with a lawyer present so the child cannot contest the will. Disinheritance is most often used when there are multiple potential beneficiaries, such as other children, and often with the intent that the sibling gives some of their estate once the addict is back on his or her feet. However, this often does not work out with family dynamics. Therefore, setting up a trust is often the best. It can either be a trust within the will or a standalone trust. And in our next edition, we'll talk more about spendthrift trusts. For additional information on wills and estate planning for children and grandchildren, visit website njlaws.com. And for assistance with the estate planning, contact Kenneth Vercammen's office in Edison at 732-572-0500.